Hello everyone and welcome to this video tutorial on Privity of Contract. Privity of Contract is a common law principle which provides that a contract cannot confer rights or impose obligations upon any person who is not a party to the contract. The premise is that only parties to contracts should be able to sue to enforce their rights or claim damages as such. And that's illustrated by this diagram here. So you can see here that these two individuals are party to a contract. There's been an offer and acceptance, there's been some consideration, they've shook on it, the contract is between them. And over here, we've got what we would call a third party. And he's a third party because he's not part of this contract. So we've got this line here showing that he's separate. So these two individuals can sue on the contract because they're part of it. But the privity rule just means that if you're not part of this contract, if you're the third party, you can't sue on it. So there's our definition. Only parties to a contract can sue each other. A third party can't sue on a contract that they're not a party to. And I've just represented this in a different diagram here. If you imagine this is the two men from the previous image that we've seen, the contract's between them, and that's the guy we saw on the previous slide, the third party. He's not part of it, and he's not given any consideration, so he can't sue on this contract. And this rule comes from a case that we've seen before when we were looking at consideration. And it's the case of Twiddling Atkinson from 1861. Recall the facts of this case. We had two dads, a dad of the groom and a dad of the bride, contracted with each other that they were going to leave the couple a sum of money. Unfortunately, both of these men died before handing the money over, so the groom wanted to enforce this contract and get his money. But as you can see here from the diagram, these two are parties to the contract. They contracted with each other, and then we've got this line showing that the groom is a third party. He was not part of that agreement, so therefore he couldn't sue on it, even though that contract was made for his benefit. But he's not a party to it, so he can't sue on it. And I've put the principle here on the next slide for you. So even though it was made for the claimant's benefit, because he was not party to that contract, he couldn't sue on it. The next case, which also illustrates this general rule of privity, is the case of Dunlop and Selfridge. So I'm going to explain the facts to you here, and then on the next slide, I've got a diagram of the facts, which will hopefully help it make a little bit more sense as well. The facts of this case are that Dunlop were tyre manufacturers, so they made tyres. And they contracted with a wholesaler called Dew. And Dunlop were selling tyres to Dew at a discounted rate on the condition that they wouldn't resell the tyres at less than trade price. So basically, because Dunlop makes these tyres, he doesn't want Dew to sell them too cheaply, because that's going to affect how much they can sell the tyres for in the future. So the agreement is they're not going to resell at less than trade price. So Dew's happy with that, and he's contracted with Dunlop. Dew then starts a new contract with Selfridge, and Dew is selling tyres to Selfridge, and in that contract he made it clear that Selfridge also shouldn't sell for less than trade price. But unfortunately, Selfridge ignored the contract that they'd signed and went on to sell the tyres at a lower price. Dunlop heard about this and were very upset, and they wanted to sue Selfridge for selling their tyres at less than trade price. You can see that this was a House of Lords decision, and the House of Lords enforced the privity rule that we've just seen in Twiddling Atkinson. So the House of Lords said, well, hang on a minute, Dunlop, yeah, you've got a contract with Dew, but you don't have a contract with Selfridge. You're a third party, Dunlop, to this contract between Selfridge and Dew, and therefore you can't sue on it. And I've put here in green as a sort of side point that the solution would be that Jew could sue Selfridge because they were a party to that contract. But obviously Dunlop can't because they're not a party to it. Jew aren't really bothered about suing Selfridge because it doesn't affect Jew if Selfridge sell them lower. Jew aren't the ones making the tyres, they're not worried about them being sold too cheaply in the future. So although they could sue Selfridge, they're not really interested in doing that. So this sounds a little bit complex perhaps, so I've tried to illustrate the facts here with this diagram. As we've just seen then, we've got Dunlop, the tyre manufacturers, had a contract with Jew. And part of this contract is that Jew are not going to sell below a certain fixed price. Then Jew goes on to contract with Selfridge to sell some tyres. And Jew has stuck to their part of the bargain and they've made it a part of their contract with Selfridge that Selfridge shouldn't sell below these certain prices either. Now, Selfridge breaks their contract. Okay, so they've ignored that and they've sold them too cheaply. Dunlop hears about it and Dunlop wants to sue Selfridge. But you can see here from the dotted line, I'm trying to show that Dunlop didn't actually have a contract with Selfridge. They had a contract with Jew, and Jew had a contract with Selfridge, but Dunlop does not. So the general rule is because Dunlop's a third party, they're not part of this contract, they can't sue them. And of course, that seems pretty unfair. Because it is of concern to Dunlop what Selfridge is doing because it's going to affect Dunlop's prices in the future. But that's the general privity rule. And it is harsh, and for that reason, there have been lots of criticisms of the privity rule over the years. Lord Denning was very much against the rule, and he said that anyone should be able to sue on a contract that was made for his benefit. So in his mind, the groom in Twiddling and Atkinson should have been able to sue, Dunlop should have been able to sue. And Denning was really recognising how unfair and unjust the rule can be, and that it's commercially inconvenient. And that really relates to what we've seen with Dunlop and Selfridge there. Dennings tried to get rid of the privity rule, but was unsuccessful in the case of Beswick and Beswick. Other judges have also been very critical of the rule. We've got a nice quote from Dylan J here about how in his mind privity is, quote, a blot on our law. And in 1996, the Law Commission also suggested that we needed to reform the privity rule. As yet, the privity rule hasn't been changed. The general rule is still in existence. However, over the years, many exceptions to the rule have developed. And that can be a criticism in and of itself, because if you've got a rule that has 1 million exceptions, it begs the question, why do we have the rule in the first place if we need that many exceptions to it? So we're going to look at each of these. First exception to the privity rule is Dunlop and Lambert, and in this case the House of Lords held that where goods had been lost at sea, in this case it was a shipment of whisky, there's an exception to the privity rule. The second exception to the privity rule, which is much more important for us and is likely to be in scenarios that you get on this topic, is the Contracts Rights of Third Parties Act from 1999. And this is a statutory exception to the privity rule. So we recognise the problems with the privity rule, how unfair it can be, and this Act of Parliament means that a third party can now enforce terms of a contract that he's not a party to, as long as one of these two situations applies. So under the 1999 Act, section 11A, if a third party is specifically mentioned in a contract, they can enforce it. So if we think back to Twiddle and Atkinson, presumably the groom will have been named in the contract between the two dads. If this act had been in existence at that time, the groom would have been able to enforce that contract under 11A. 11B says that a third party can enforce the contract if it purports to confer a benefit on them. So that means if they've not been specifically mentioned by name, say, but you can tell from the way the contract's written that the contract is supposed to confer some sort of benefit on them, then they can enforce it. So if you think back to Dunlop and Selfridge, it might be that Dunlop was not mentioned at all in the contract between you and Selfridge, but a judge would be able to tell that the whole point of the term in the contract between you and Selfridge was to benefit Dunlop because it's going to affect how much they can sell tyres for in the future. So they'd be able to enforce under this Act as well. However, people entering into a contract can avoid this Act applying if they simply state that they don't want the contract to be enforceable by third parties. A case example of where the 1999 Act has been applied successfully was Nishin Shipping. And in this case, Cleves was able to enforce a contract as a third party because it was clear that the contract conferred a benefit on him. Just be aware that there are other statutory exceptions to the Privity Rule as well as the 1999 Act. So before that Act, we had the Married Women's Property Act and also the Road Traffic Act. So be aware that there are other acts that are exceptions to the rule as well. Our fifth exception to the Privity Rule is something called a collateral contract, and this is illustrated in the case of Shanklin Pier. And I think this is a bit easier to understand if we look at a diagram of it to help illustrate the facts to begin with. The facts of this case are that Shanklin Pier over here hired a contractor to paint the pier. And they spoke to Dettol Products, who was a company that produced paint. And they asked this company what paint was suitable to be used, and Dettol assured them that this particular paint would last for at least 7 years. So on this basis, Shanklin Pier, when they hired this contractor to paint, they said, we want you to use this Dettol product paint because it's going to last 7 to 10 years. So the contractor then goes and buys this paint, paints the pier with it, and unfortunately it starts to peel after just 3 months. So Shanklin then wants to sue the paint company that have told them that it's going to last and it hasn't. And you can see from this diagram that we've got the classic privity problem here, because the contract with the paint company was not actually with Shanklin Pier. So the contract was between the contractor and the paint company. So there's your contract. And Shanklin is a third party behind this line. So the general rule is, as a third party, Shanklin can't sue the paint company. However, Shanklin only instructed the contractor to use that paint because of a promise that the paint company had made. And this is basically what a collateral contract is. So if I switch back to the previous slide here then, the claimants, as I've just said, Shanklin Pier couldn't sue on the contract for the sale of paint because they weren't a party to that contract, but they could sue Dettol Products on a collateral contract arising from their promise as to how long the paint would last. And that seems fair because, of course, the contractor only used that paint was only bought because of the promise that Dettol had made to Shanklin. So look out for promises in your scenarios. Final exception is agency from New Zealand Shipping. And if we look at a diagram to illustrate the facts here, we had a contract between A and B. And one of the clauses in their contract was that there was no liability for damage by an independent contractor. Over here, our third party, independent contractor, damages a load of goods. He wants to rely on that clause in their contract. In this case, the court said that there was an exception to the privity rule and he could enforce that clause because he was acting as an agent between A and B. He was carrying out their contract, so therefore it was fair for him to enforce it, sorry.